Good morning, and thank you for joining us at Kindur for a webinar to discuss the Secure Act and how it might affect your estate planning. Just to introduce who we have here today, my name is Alastair Wood. I am Kindur's General Counsel, and I'm very pleased to be joined today by Nancy Welber, who is an expert in estate planning with a specific focus on estate planning with retirement assets. And today we are going to talk about the Secure Act, which recently passed and became law, going into effect in January of 2020, and how it may impact your estate planning. Let's just start with what is the Secure Act? You've probably, if you've been watching the news or reading any sort of pieces on retirement lately, you've probably seen a number of articles discussing what a significant potential change to the U.S. retirement system this act is going to be. The act contains a lot of really great beneficial provisions that will help Americans save more for retirement. This includes allowing Americans to save into IRA accounts without any sort of age limitations. It increases the age that you have to take RMDs out, which allows your account to grow for longer. However, we're not going to focus on those provisions today. What we're going to talk about today is how the Act actually impacts passing on those assets to your beneficiaries and to your next of kin. And specifically, the elimination of the so-called Stretch Ira, which has been a cornerstone of retirement estate planning for many Americans for generations. And maybe, Nancy, if you could just give us a little bit of understanding of what is the Stretch IRA and how did it work?
Sure, Alastair. So the Stretch IRA is something that really affects non-spouse beneficiaries. So let's start out by saying spouses get a Stretch IRA by rolling over or sometimes even taking an inherited IRA. Spouses are not affected by this act. So we're really talking about your non-spouse beneficiaries, children and others that you might benefit after your death. Under the old rule, a beneficiary was allowed to take minimum distributions. In fact, they had to take minimum distributions regardless of age, starting the year following the year of the account owner's death. But it was based on the beneficiary's life expectancy. So their RMDs were very small. If you had a child, for example, who was 25, they literally had somewhere in the neighborhood of 60 years of stretch. But what happened with Secure is that this was completely upended. And now, instead of having a Stretch IRA, the IRA can only go out in most instances for a 10-year period. So it's a drastic reduction for most non-spouse beneficiaries. So I do want to talk about how this is going to work for everyone. So a little bit of review. The code and regulations that govern minimum distributions has a bit of a hierarchy of beneficiaries. The spouse is the most favored beneficiary, followed by other individuals, usually children or grandchildren or others who are individuals. In the middle, we have what are called see-through trusts, which is a colloquial word used for certain trusts that qualify their underlying beneficiaries as designated beneficiaries. Then we have situations where we have charities named as beneficiaries or trusts that don't meet that see-through classification, and finally estates that are named as beneficiaries. So that's sort of the hierarchy of beneficiaries, but we really had previously two categories of beneficiaries. One category was the designated beneficiary, and under the code and regulations, that is really code words, shall we say, for an individual beneficiary. So all designated beneficiaries are individual beneficiaries, and we'll talk about that later and how that works with trusts. But any entity that was part of your beneficiary designation, if not handled in certain ways or part of a trust, was not a designated beneficiary, and that remains the same. So talking about charities or estates, things of that nature. So that's the old rule. But now the new rule splits the designated beneficiary into two classes. One class I will call the ordinary designated beneficiaries, and those are, generally speaking, your children and your adult children, I should say, and others that you might benefit. But we also have what are called eligible designated beneficiaries now, and there are 5 categories of eligible designated beneficiaries. The spouse is one of them. Your minor children. Now, when I say minor children, these are minor children of the account owner. So grandchildren, your grandchildren, do not fall into this category if you are grandma and grandpa. Or if you have nieces and nephews, they don't qualify for this category. They must be your children. In addition, there are special categories for disabled or chronically ill beneficiaries, and those I'll discuss in just a minute.
Just interrupt, Nancy.
Sure.
These are categories of people who are still able under the Stretch IRA, under the Secure Act,
correct,
to stretch their IRA.
Right. So exactly. Thanks, Alastair, for making it clear. In other words, these eligible designated beneficiaries, because you notice the spouses in that category, are allowed to stretch the IRA still under the old rules. So those of us who do this for a living need to know both the new rules and the old rules. And finally, if you name someone who is not more than 10 years younger than you, like your sibling, for example, might be an older or younger sibling, but is fairly close in age to you, they also get this benefit of the Stretch IRA. And what does that mean? They get to use their own life expectancy to determine how long they have to take those benefits out.
Now, that's helpful, because I think that addresses a lot of the people who you may leave as a beneficiary that you're worried about. But many Americans who have been thinking about estate planning may have trusts that they've set up. And I think one of the things that would be helpful to understand is how does the Secure Act affect any trusts that you have that are going to take IRA or retirement assets?
Well, that's one of the areas that unfortunately is the most unsettled at this point. The current regulations really don't mesh very well with the new secure rules. So we're going to be waiting for those regulations to be revised. One of the things that we can tell you, and we means estate planners like me that are in this community, can tell you is that a lot of the rules will apply. So, for example, in order for your minor child to be able to use their life expectancy for a portion of the stretch that they'll be allowed, you will have to do a trust that pays all of the distributions out to the child. And we'll get into that in more detail. But suppose you have a trust that's in existence now, and you really wanted it to be able to use that life expectancy payout. So the only thing that was going to be taken out of the IRA over the course of the entire trust, or the lifetime of the beneficiary, were the required minimum distributions. And let's say they're not one of these eligible beneficiaries. So it's maybe an adult child. Well, instead of taking it out over 40 years, now they have to take it out over 10 years. But what's more, the way that the 10-year rule will work is that there is no requirement to take any money out until the 10th year, when the entire account has to be liquidated. So what that means is, if you have a trust that says you must take all required minimum distributions and distribute it to the beneficiary, that's going to probably have to be changed. Not always, but probably going to have to be changed, because there'll be no requirement in the first 9 years, but in the 10th year, there'll be a lump sum distribution of the entire account balance. So what that's going to mean for you is you should pay a visit to your estate planning attorney and discuss the alternatives that are going to be available to you for planning. In some instances, that may actually be a good way to plan, but in others, you may want to add flexibility to that trust to allow a trustee to take distributions out to take into consideration not only needs like health, support, maintenance, education, which are pretty common, but really also the tax bracket that your either adult child or even minor child might be in. So those are some of the considerations. The other consideration might be what type of plan is going into this inherited account. If it's a traditional account, then you may want to be taking some money out every year. But if it's a Roth account, you may want to be able to let it sit for the 9 years and finally at the last possible moment in the 10th year, pay it into the trust tax-free. So there are a lot of planning issues that really have to be resolved.
Well, Nancy, that's incredibly helpful. I mean, I think it sounds like the answer here is it's complicated, and if you have a trust, you probably are going to want to have it looked at just to make sure that the Secure Act hasn't changed the rules, and it's still the trust will still do what you had set it up to do.
Right, or it may not do exactly what you've set it up to do, but it'll be as good as we can get it given the new rules. What I would say is, unless there's some compelling reason why you must get this changed now, I would say walk, don't run to your estate planning attorney. Besides the fact that they're all going to be very busy, the reality is until the regulations are issued, it may be a bit of a guessing game. There are a lot of things that we don't know. So I'd like to turn back for a second to the minor child exception because it's particularly unclear. Under the tax code, a minor child is technically a child who has not attained the age of majority. But what's interesting is we don't know what the age of majority is for a couple of reasons. It differs from state to state. And in addition, under the regulations, a minor child's age of majority, the time when they reach the age of majority, may be extended to as late as age 26 if they're in a specified course of education. And we don't know what that is either. With regard to the age of majority, I am speculating, and this is just my own personal guess, that the IRS will adopt a uniform age, which again, I'm speculating will be age 21 for the entire nation, because frankly, it will be easier for them to track that as opposed to having a 50 state, having to deal with what it is in each state, because it's different for certain different purposes under property laws in different states. So that's just my speculation, but stay tuned if you have a minor child to see whether, number one, they qualify for a lengthened stretch, which, by the way it's going to work is they will be able to use their own life expectancy until they attain the age of majority, whatever that turns out to be, and then the 10-year rule will kick in. So somewhere the IRA will end somewhere between the age of 28 and 36 for the minor child beneficiaries.
So I guess stay tuned, more to come.
Exactly.
I think one of the questions that our viewers and our listeners have is, what should I do now? What possible actions can I take now to really help take my estate plan and incorporate what's happened with the Secure Act? And I think one of the ones that we hear a lot about is Roth conversions. And just to kind of set the table, for those who don't know what a Roth conversion is, basically if you have a traditional IRA, the way it works is that you pay tax when you withdraw funds from the IRA, because you contribute pre-tax money into it. A Roth IRA is different. That is post-tax money that you contribute to the Roth IRA. So the IRS doesn't tax you when you take the money out. Now, with a Roth conversion, what you do is you take all the money out of your IRA, you pay tax on it when you take it out, and then you fund a Roth IRA. And then that Roth IRA does not pay tax later.
Let me just say one thing. You may take it all out of your traditional IRA. And there are a couple different ways that you may be able to also do it if you're rolling over from, for example, if you're on the verge of retirement and you're going to roll over to an IRA from your employer plan, you may have options for conversion. And if you have pre-tax money in the plan, not Roth money, but other pre-tax money, you may be able to get that tax-free to the Roth. But bottom line is, you could also do this on a systematic basis. So let's say you have a traditional IRA, you could take a certain amount out every year going forward so that you stay in the same tax bracket, or maybe you bump up to the next tax bracket if that tax bracket is only, say, 2 percentage points higher than the one that you're in order to do this over time and not cost a lot of extra money in taxes for the conversion.
And that's an excellent point. That's something that when you do this Roth conversion, there are ways to minimize the amount of tax you're paying now. The ultimate goal of the Roth conversion is to get the money into an account that when you pass it on to your beneficiaries, they will not have to pay tax on this. Now, maybe Nancy, you can explain for us a little bit more why that matters when you're talking about estate planning.
Sure. Well, estate planning, one of the issues that's really important, especially if you're using trust, but anytime you're taking income tax, something that's subject to income tax out, this money is going to be forced out at a fairly high tax rate if you've got to take it out over a 10-year period. So you're trying to do something now that may cause you a little pain, but eventually your heirs will pay less in income taxes. In addition, the other thing that a Roth conversion does for you is it stops minimum distributions. Roth IRAs during your lifetime have no minimum distribution requirements. So if you have a fairly large amount in traditional accounts and you're taking minimum distributions or will be taking them and you don't think you'll need them, then you can this could be a rainy day fund just in case you do, but also something that you'll be able to pass on eventually to your children without income tax. So there are a lot of advantages, and you definitely want to think about financially what makes the most sense for you.
That's great. And I think when you also think about evaluating your estate plan, I think the Secure Act has also caused people to actually think about who are the beneficiaries they name for these retirement plans, and how that actually will become a tool for estate planning.
Yes. So if you don't have any of these eligible designated beneficiaries in your family, so that you don't have to worry about it, it may be that there's nothing that you really have to do. In other words, if it's all going out right to your spouse or to your kids, you just need to know that with your kids, it will come to them much faster and at a higher tax cost likely than it will under the old law. If there are eligible designated beneficiaries, especially if you have a child or another relative who is either disabled or chronically ill, there actually is a special carve out for trusts that meet the rules that allow them to use their own life expectancies to determine minimum distributions under the new law, but also qualify them for means-tested government benefits like Medicaid and Supplemental Security Income, SSI. And that's really important. For those of you who may be familiar with that, the disabled or chronically ill criteria are a little bit different than those for Social Security disability income or SSI, because it has to be of indefinite duration. It has to be it's not just more than 12 months, but indefinite duration. Likewise, chronically ill. And chronically ill would be someone who would qualify to receive long-term care benefits under a long-term care insurance contract, which doesn't mean you have that kind of a policy, just that they could qualify for benefits, either because they need supervision with certain activities of daily living, or they have a cognitive impairment such as dementia or severe mental illness. So you may want to take your IRA and put more of that traditional IRA type asset toward those beneficiaries, but more of your taxable assets towards the other beneficiaries. And as I say to my clients, sometimes what's fair isn't always equal. So you may be able to equalize those other beneficiaries who say, yes, but my brother is getting more than I am. Well, yes, but they're going to be paying income tax on that, but at a much lower tax rate. So you really are going to have to drill down into everyone's needs, into their tax brackets. There's going to be a lot more financial planning to be done with these different options and requirements, so that, as well as estate planning, because you're going to be probably changing around trusts and possibly beneficiaries as well.
And maybe, Nancy, you could talk a little bit about life insurance, which I've heard a lot of people talk about post-Secure Act. There may be a need to buy life insurance to kind of replace lost benefits.
Sure. Back in the day when we had a much lower estate tax exemption, buying life insurance, especially in a trust that was not part of your taxable estate, was a very common technique, but that's fallen by the wayside for people that don't have large estates to some degree. Well, it may just have come back into vogue as of the new year, because one of the ways to help cover some of the benefits lost to income taxes with the Secure Act may be to buy some life insurance to smooth over some of those lost benefits. And you should, of course, talk to your tax advisor, and also think about, the estate tax is a little bit of an unknown, frankly, because of the election coming later this year. The outcome of the election may have a lot to do with where the estate tax exemption goes in the coming years as well. One of the other things, and I think this is up on your screen right now, it's talking about disclaimers. And let me discuss what a disclaimer is by a spouse or a child. So someone can, let's say, the husband dies and leaves all of the retirement benefits to his surviving spouse. The spouse can say, I don't need $3 million of benefits, but I could use 2 just to make sure that I'm going to be okay. I'd like to get some to my kids. Well, within 9 months of the date of death, the spouse could say, don't give them to me, and then they would go to their children. Well, it's not quite that simple. It has to be in writing. It has to be within 9 months of the date of death. You also can't take any of the benefits prior to making the disclaimer, nor can you direct where the disclaimed benefits go. So this is something you need to plan for in advance. But what it can do is it can get, especially if your children are in a lower tax bracket, it can get those benefits to your children when they are in this lower tax bracket, and actually may be able to use them. Or even to grandchildren, for example, if your grandchildren are adults. So it's something to explore, and frankly, something I use fairly often in my own practice. And instead of having to rely on a disclaimer, you may name children as the beneficiaries of a portion of the account. It won't preclude a rollover by the surviving spouse. You could also, if you're charitably inclined, think about leaving some of your money to charity, the retirement benefits. Because a charity is tax exempt, they are great beneficiaries for retirement benefits outside of trust. It's very difficult to name them within a trust, but outside of trust, they're terrific beneficiaries if you're so inclined, because they don't pay income tax.
Well, that's incredibly helpful. I think one of the things that's important that comes out of this, that I think Nancy really made clear, is that there's a lot of changes, and there's an interesting tie here between how you manage your accounts and what you're going to do with estate planning. And that's one of the things here at Kindur that we help with. We can help you figure out what your required minimum distributions are, what the best sequencing is. If you decide that a Roth conversion is right for you, we can help you execute all of those things in a very technologically forward way to really help take account of the new law. With that, I'd love to turn it over and see if there are any questions from our audience that they have asked. And I see one has already popped up, which is, what happens if I've already inherited an IRA? How does this affect me? So maybe Nancy, I'll let you take that one.
Sure. So if you've already inherited an IRA and you're taking minimum distributions from someone who passed away in 2019 or earlier, you just continue taking those minimum distributions over your life expectancy. What probably will happen, there's a little bit of a discussion among those of us who do this work about exactly how it'll play out, but it would appear that when you name your own successor beneficiaries for those benefits, they will be paid out over 10 years. And I'd like to add that if you are married, this is the type of IRA, an inherited IRA, that does not qualify for a spousal rollover. So it's possible, but don't count on it, that that your successor beneficiary will be able to continue the benefits based on any remaining life expectancy you haven't used up, in the sense, at your death, but you should be planning for the fact that it's more likely to be paid out over a 10-year period. Now, if you live to a ripe old age, it actually might be more than they would get otherwise. But that's something that will be sorted out in regulations.
So we've had another question come in. Can you talk a little bit about how the Secure Act impacts annuity options in 401k plans?
Yeah, well, I can talk a little bit about it. There are new, the Act did expand annuity options within 401k plans for employers. So there isn't a lot of discussion about that at this point, but employers may choose to offer them more widely. And I believe they're going to be more portable. In other words, if you change jobs, you'll be able to take them with you more easily than you would now. So I think that's sort of the basic issue. More will be coming out on that, I think, over the course of the year as that gets implemented. But I think that's sort of where we are with it now. And I think you should stay tuned to see if your plan is going to offer it.
Thanks, Nancy. And we have, I see, a question coming in. Just so everyone who's watching knows, all you have to do is type a question to us and it'll pop up on our screen, and we'd be happy to try to answer it. So this question is, how does the Secure Act impact a Roth 401k?
That's a good question. The Secure Act impacts a Roth 401k in the same manner as any other retirement plan, whether it's a Roth or not, so any 401k. The rules for a Roth, whether it's a 401k or an IRA, they're subject to the same rules as a regular 401k, shall we say, one that's a traditional, as I like to say, 401k, except when the Roth rules override it. So it really does still have the same 10-year issues and things like that. One tip I will give you is, if you have a Roth 401k, a Roth IRA is not subject to the minimum distribution rules, but Roth 401ks are. So if you're planning to retire soon, or even if you aren't, and you are able, because let's say you have a traditional IRA, you should start a Roth 401k, a Roth IRA as soon as possible. It can have a minimal amount of money in it, but you should start it as soon as possible, because even if your money has been in that Roth 401k for more than 5 years, that 5-year period that's required for your Roth to be completely tax-free does not carry over to the Roth IRA. So if you were to do a rollover from your Roth 401k to your Roth IRA, even if you're over 59 and a half, even if it's been in the Roth 401k for more than 5 years, if you don't have a Roth IRA already available and that has been in existence for 5 calendar years, then you are going to have to start the 5-year period over. So I would try to set up, if possible, a Roth IRA as soon as possible if you're in that position.
That's fantastic advice. And I guess the answer is on the Secure Act. If you have a Roth 401k, you're still going to be subject to the 10-year rule.
All the rules are the same. The only difference is that if you're in a Roth, if your beneficiaries inherit an inherited Roth IRA, or actually an inherited Roth 401k, the distributions will come out tax-free to them. But in terms of how that will impact you or your spouse, there won't be any difference. Your beneficiaries will have the 10-year rule. Now, they may not take it out until the 10th year because it's better for them, but they'll be probably under the 10-year rule unless they're one of the eligible designated beneficiaries. But it really doesn't, there's nothing special about having it in a Roth 401k as compared to a traditional Roth or traditional 401k plan under Secure.
All right, well, thank you, Nancy. That's incredibly helpful. I don't know if there doesn't appear to be any other questions. So with that, I will wrap up and say I hope everyone found this informative and helpful. Here at Kindur, we are always available to help you at any time deal with these issues. Feel free to either email us at support@kindur.com, or you can always call us as well to speak to a financial advisor. You can also reach us on our website, which is www.kindur.com. I'd like to thank Nancy for joining us today.
It was my pleasure.
It was hopefully educational for everyone who watched. It was certainly educational for me. And if we can ever be of help, please don't hesitate to contact us here at Kindur. Thank you.